what I thought I would do today is to give you a little bit of background information about why this project is important, about some of the features of United States copyright law that it is founded upon, about the methodology and the outcome of the process, which, as Janet said, we engaged in over a 2-year period. And then I want to spend some time talking about what's in this book, and especially what's in it for you at the point in your careers that we now understand you occupy. And now I'm going to see if I can get the slide to change. So here's a document, looks like this. It's available online at the CAA website. This is one of the first things we did in this project. Before we ever got started with the work of developing the small book, which has norms in it, we first wanted to see what was actually going on in the field. How were people in the visual arts community, which includes both art scholars and art historians and teachers and art makers and curators and gallerists and publishers. It's a big organization, and others. So we spent a year talking to people, administering a questionnaire, trying to figure out how people in this community writ large were experiencing copyright law, what it meant to them, and in particular, how it impinged on their work, whatever, as I say, that work might be, whether it was mounting a show or writing a catalog or publishing a monograph or painting a picture. And it's a good read, and it has some interesting findings. The first, and I suppose, as Janet suggested, that this isn't exactly a big surprise, is that in a field like visual arts, people interact with copyright a lot. And in particular, that in doing their own work, 70% of people across the field, in all of the professional categories to which I referred earlier, said, yes, we need to make use of other people's copyrighted work, or what we at least believe to be other people's copyrighted work, in order to do our own work. 70% of the respondents in the survey, and an equivalent number of those who we spoke with in long-form interviews, said that. That was really interesting. So the obvious follow-up question is, well, how's that working for you? Are those interactions positive interactions, or are they sometimes a source of frustration? And what we learned is that the frustration quotient was fairly high. It differed a little bit. This slide kind of sort of smooths things out over the whole community, but the frustration quotient in general was pretty high. Fully a third of people we talked to and those who were surveyed said that not only had they sometimes been frustrated by demands for compliance with copyright rules, but at least in a third of their cases, a third of them said, you know, this is more than simply a background bother. This has caused me to change my work. This has caused me to give up projects that I would have otherwise undertaken. This has caused me to drop projects I was in the middle of. This has caused me to do a less good job than I would otherwise have liked to do, to use fewer illustrations when my argument would have benefited from using more. This has caused me to choose my field of research, or to recommend to a student that he or she choose a field of research that is outside of the 20th century, which is, of course, the battle zone, 20th and 21st centuries, the battle zone where copyright compliance is concerned. Why bother with modernism when there's always the Renaissance? And so we heard a lot of things about how demands for copyright compliance were kind of twisting askew the actual performance of professional functions If you wanted to be sort of highfalutin about it, you could even say professional missions in this field. And I've focused in what I've just said on scholarship. We heard the same thing about teaching. We heard the same thing about museum work, curatorial work, and so on and so forth. So there's a real issue here. And we were interested. There's a lot more narrative and statistical detail in the report if you're interested. And so we thought, well, maybe it's time then to go back to first principles and ask whether this should be so, whether this degree of conflict between the copyright system on the one hand, at least as perceived, and art world professionals was really inevitable, or whether something might be done about it. And so going back to first principles in the case of copyright means going back to the founding documents of our republic, the Constitution among others, and the early cases decided in this area by the United States Supreme Court. And all of that material, there are things about constitutional law, which anybody who reads the newspapers knows are highly controversial, subject to a great deal of argument among experts. This one isn't. This is straightforward. Everybody agrees. It's self-evident. There's only one reason for copyright to exist in the United States of America, and that is to promote the making and the dissemination of culture. This is not a jurisdiction which, like some European countries, for example, believes or says it believes, sometimes I wonder, in so-called authors' rights as the foundational principle for intellectual property law. In the United States, the only reason we hand out legal benefits to authors is that we believe that by doing so, we are giving them an economic incentive to make and push out for all the rest of us to read and see and hear and otherwise use new stuff. Very important proposition, easily lost sight of, but in fact non-controversial. So I've just mentioned one of the ways in which copyright law, which awards a limited monopoly into new pictures and new writings and new computer programs and new practically anything else you can imagine, to the creator, is supposed to work to promote the making and the dissemination of culture. There's another one too, not just rewarding creators, but also encouraging new makers to engage with, to take advantage of, to build upon existing culture. Well, how does copyright do that? It does that by being porous. It does that by being a less inclusive, less generally restrictive form of property interest than some of the other property interests we know about in law: property in land, property in chairs, property in beautiful old buildings like this one. Copyright is full of holes, full of gaps in its protection, and those are not an accident. They are features rather than bugs of the copyright system. We know about some of them. Some of them have been in the news. We know that copyright is supposed to be limited in its length so that after a certain point in time, everything becomes free for use. Well, it hasn't worked out so well because over years, the Congress of the United States has seen fit and the courts of the United States have winked at its practice of extending the duration of copyright, not once, but multiple times. Still, there are other features in the copyright law, other kinds of porosities, other kinds of designed-in gaps, which are supposed to be encouraging to new makers. And here's the most important of them. We can talk later if you're curious about some of the others, but the biggest balancing feature in copyright law, the biggest offset, if you will, to the legal authority that copyright law gives to creators, and of course subsequently, because copyright is long and life is short, to creators, heirs, and estates or to companies to whom creators or creators' heirs and estates have transferred their rights and so on, the biggest offset that copyright in the United States comes in the form of the fair use doctrine, which is written down in the Copyright Act, has been since 1978 in what is called Section 107. And it's a very big idea, and it's an important idea. Basically, the idea of fair use is that not every unauthorized, unlicensed use of a copyrighted work is necessarily wrong. Not all unauthorized reuse of copyrighted material is infringing. It depends. Sometimes such uses, and we're going to see in a minute when that sometimes is, are permitted, even encouraged, rather than penalized. That is, when they are deemed fair uses. Now, why have such a doctrine? Well, I've already explained, I hope, in sort of functional copyright terms, why it's important to have gaps, including this one, in the copyright monopoly. But there's another reason, too, and it's worth paying attention to, especially because the good justices of the United States Supreme Court from time to time see it necessary to remind us of it. And that is, we don't just have fair use as a offset to proprietary rights and copyright because it makes copyright work better. We hope that does. We hope that's the case. We also have it because in addition to including an authorization to Congress to enact copyright laws, the Constitution of the United States also has this First Amendment in it. And of course, if you think about copyright law, which basically is about stopping people from speaking in advance or penalizing them for having spoken in certain ways after the fact, you can see immediately that there's a certain tension with the principle of freedom of expression. The two things don't live comfortably together. They need to be harmonized in some way. And the Supreme Court has said it's this fair use doctrine that harmonizes the freedom of expression principles of the First Amendment with copyright so that the two can sort of, live happily or more or less happily together. Here are a few teaser points about fair use before I get to the essence of what it is. The first one I include only because sometimes there is confusion about this. When a use that you contemplate making is a fair use, then by definition, that means you don't need a license, you don't need a permission, you don't need an authorization, you don't have to pay a royalty to make it. That's the essence of fair use. Another general point about fair use is that every fair use decision, every decision about whether or not to use particular material without license under fair use is to some extent a function of context. There are a bunch of things you have to take into consideration which are specific to the situation. And we'll talk later about what some of those are. What that means, however, is that fair use analysis doesn't reduce easily to rules of thumb or even to rigid guidelines, flowcharts, maybe, but not so much. You find a lot of this stuff around. You find it in books, unfortunately. You find it on the web, inevitably. People who want to make this simple, who want to say less than 50 words of a quote from a letter is fair use. No, there's no such rule. No one ever could be more, it could be less. Those rules of thumb, those are the urban folklore of copyright law. And I hear another one every time I go out to speak. I talked to a music crowd the other day, and they told me about the 4 changes rule. Do you know the 4 changes rule? If you take a piece of music and you make 4 changes to that music, they could be I guess I'm not a very musical person, but I guess they could be, tempo. They could be notes, chord changes, and now your use is fair. I mean, that's bizarre. And yet there are people in that field who believe it to be true, and rules like that get transmitted throughout the field from grizzled veterans to young tyros, and you have to resist the siren song of these rules of thumb. Guidelines almost never work because they're static rather than dynamic. And nature in the field is, of course, by nature dynamic. Flowcharts, well, again, maybe, but they don't get you all the way home. So the question is, well, okay, let me talk about a few more predicate propositions. Often, people say, well, I get this fair use stuff. I get that there may be circumstances under which if I'm writing an article that has 20 illustrations, I might be able to make an argument for using some of those illustrations pursuant to fair use. But there are other illustrations in my article that I really would like to pay for. I'm trying to play nicely with a particular artist's estate. And I think they're going to like me more in the future if I cooperate and pay them some licensing now, even though I may not actually be required to do so. And so then the question is, I guess I'm stuck then, because if I license one thing, one illustration for my article, I have to be consistent, right? And license all the other ones too. No, there's no such rule. And again, we've been told on the highest authority, as far as law goes, the Supreme Court, that that's not the case. So fair use can be used selectively and opportunistically. It doesn't have to be used uniformly across the board. Similarly, and here I'm afraid sometimes lawyers are actually the source of the misinformation. People will sometimes say to you, well, if you think you're going to use fair use, for heaven's sake, don't ask permission. Because then you're acknowledging that the rights holder has something that you need in order to continue. And that's complete nonsense. Of course you should ask permission if you're inclined to, and if you think there's some reasonable chance that you'll get it on terms that might be satisfactory. And if the rights holder says no, or if the rights holder says yes, but there's a huge price tag that's completely out of proportion to your budget attached, then you go ahead and consider whether it's a fair use after all. Asking never hurts. It can only help. So, one more thing. And again, I guess this slide is really about stupid things lawyers say. Because one thing that lawyers say that's wrong is never ask permission if you're going to do fair use. Always be consistent. Not true. The other thing that sometimes lawyers say is, remember, fair use isn't a right. What could they say? They might say it's a privilege, but not a right. Well, that's wrong because it says right in the Copyright Act in Section 106F4 that it's a right. But it is a right and not an obligation. If you have good reasons not to exercise your fair use rights in a given case, you can, of course, decline to do so. You should, from time to time, just to keep the fair use muscle strong. Rely on it, but it's not a duty. It's just one more tool in your toolkit as a visual arts professional. So when you go to the statute or when you read online some summary about fair use, you'll learn correctly that the statute directs courts that are trying to decide whether a use that took place in the past and has now been challenged is fair to consider four things. And of course, those four things are also the things that somebody who is contemplating making a fair use should consider before the fact. What's the use for? What's the purpose? What kind of material are you using? Is it very factual? Is it an entertainment work? That might matter. How much did you use? and what was the effect of your use on the market for the work. Now, these are great, except standing alone, they are almost devoid of meaning. They are so general and so open to interpretation that without some guidance, they actually often, I think, discourage rather than encourage the users or communities of users to rely on the doctrine. And the courts know that. This is, after all, their domain. They're supposed to interpret this stuff, and they've been doing it, and they've been doing it especially actively for the last 25 years. And they've said, look, it's all very complicated, those four factors. But really, in situations like the ones that we're facing, where we're talking about, let's say, discursive reuse of pre-existing materials, the use of pre-existing materials in order to make a new argument, to tell a new story, to present a new thesis. Well, the courts say in cases like that, there are really only two considerations that matter a lot. One is, going back to the first factor, what exactly, again, was the purpose of the use? And in particular, the courts will say, adopting jargon of their own that has become pretty endemic in decisions about this question, is the purpose a transformative purpose? And that sounds vague, but it's really not very vague at all. It means simply, are you doing something different with the material from what the original maker of that material had in mind? So if I, for instance, am writing a review of a book, and I want to quote a block of text to show what a good book it is, or perhaps to show what a bad book it is, I'm doing something fundamentally different with that block of text than what the original author was doing. I'm using it as the object or focus of critique, whereas the original author was using it as a to entertain or to provoke insight or to develop a thesis, a transformative purpose. When you see a documentary film about a social issue in which, as part of the exposition of the development of that issue, news broadcasts, we've been seeing a lot of that stuff now in the last few days in the 10-year Katrina retrospectives. We've seen a lot of news broadcasts from both national and New Orleans outlets from 10 years ago. And those are being used now in a completely different way from their original purpose. They were originally designed to report on breaking events, and now they're being used as historical markers to reflect on those events, their causes, their consequences, and so forth. So that's the big question. Is there a transformative purpose at work? And in the kind of work that people in the visual arts community, whether they are writing scholarship or whether they are creating exhibitions and catalogs to accompany them, or whether they are making new art out of, among other things, existing art, the likelihood is really pretty high that transformative purpose is involved. Then the courts say there's another really important question, and that is, did you take a reasonable amount of material? So if I am writing that review of a book that I mentioned earlier, well, now let's do the documentary film. If I am doing a sort of 10-year retrospective report on flood control in New Orleans in the aftermath of Hurricane Katrina, I'm fine using 2 or 3 minutes, perhaps, of a contemporaneous news broadcast. But if I decide that I'm going to put the whole 10-year-old broadcast on my news website, for example, I may well be using an inappropriate amount, more than is reasonably related or justified by my purpose. That's it. That's the heart of fair use analysis today. And in fact, if you want to know more about this part, there is in the back of the little blue pamphlet a short, I suppose, essay that I wrote with a lot of help from my collaborators. It kind of sums up this stuff about the state of the law. I don't want to dwell on it much further. We can come back to it in questions if you like, because we have more important work to do. But I do want to say one more thing about the state of the law. If you look at the last, let's see, how many decades have we got? Well, about 175 years worth of U.S. court decisions involving fair use. You see something very interesting, and that is that courts that are looking at what constitutes fair use in a particular field, say in biographical scholarship or in entertainment filmmaking, want if they can to determine what people in the field, what makers, what active creators in the field, remembering of course that fair use and copyright are all about encouraging creativity. They want to know what people in the field think is appropriate. And when what people in the field think is appropriate has been well documented, then it is an important source of information and guidance to courts themselves. So it all sounds great, right? You can immediately see, I hope, that this has powerful potential implications for work in the field, and indeed for the work that many of you have begun or will soon be beginning to do in your studies. But as the original document shows, for some reason the visual arts field hasn't yet fully embraced the good news about fair use, even though the good news is by no means new news. We still, and I'm not really singling out visual arts because the same thing is true in any of the practice fields in which Pat and I have sort of delved and dabbled in the last decade. We as communities of practice, don't squeeze this doctrine for the value that it has to give us. And then, of course, afterwards we complain about copyright and all of the frustrations it's imposed on us, despite the fact that we might have been able to avoid those frustrations if we had taken a little more agency. Why don't we? Well, we think lightning is going to strike. We think we're going to be the one serious professional in 1,000 or in 10,000 who actually ends up on the wrong end of a lawsuit. So unlikely, but still we worry about it. Low probability, the risk of low probability events can, perhaps irrationally, nevertheless be a real source of constraint. We worry a little bit about relationships. We worry about that if we get known as aggressive advocates of and users or employers of fair use, we may lose reputation in the field. We worry about bad publicity. And of course, especially if we're relatively junior in our field, we worry about what more senior people tell us we are supposed to do. We worry about the rules of our institutions. We worry about the policies of our publishers. We worry about all the things, all the restrictive interpretations of copyright law and the necessity of copyright compliance that are generated and publicized by what we sometimes in this work refer to as gatekeepers. Not our adversaries, not the copyright owners, but our friends, the people we're supposed to be working with, who are supposed to be making life easy for us, who are supposed to be cooperating with us in the fulfillment of our projects, but who sometimes take risk too seriously. Institutional lawyers, oh my goodness, are a very, very important part of this problem, I'm ashamed to say. Of course, the only risks here are not risks of getting into trouble, of getting into hard trouble or soft trouble, or of getting our institutions into trouble. There are also risks in not taking advantage of fair use. And those are pretty significant risks too. If we allow overstated demands for copyright compliance that do not take fully into account the existence of the right of fair use to influence the kind or quality of our own work, again, whether we're artists or scholars or curators, for the worse, then that's a bad thing too. Anybody who's involved in cultural work that entails engagement with copyright has to engage in a certain amount of risk management behavior, a certain amount of balancing of risk. And that, of course, begins with knowing your real position, including your rights. And that's where the second part of this project comes in. That's where the blue booklet, which is the most recent addition to a family of similar best practices codes, which, as I've said, my collaborators and I have been working to develop with a very now large handful of different creative communities throughout the last decade come in. These aren't guidelines, they aren't checklists, they aren't mechanical documents. They're guides to reasoning. They describe ways of thinking through fair use issues to a robust, defensible conclusion. You can read them up and down and backwards and inside out. You won't find any word numbers or percentages or other false metrics. They aren't the result of, locking representatives of the practice community in a room with representatives of copyright owners and sliding pizzas under the door and telling them that they can't come out until they've agreed on consensus standards between them, because those never work. You always get, in the end, so-called guidelines that are, in fact, tilted very, very, very strongly toward the interests of copyright owners. They are based on professional consensus in the field itself. The methodology behind these fair use guidelines is to consult at length and in detail working professionals in the field and to distill from those discussions a consensus, as strong and robust a consensus as the discussions will bear, about what constitutes legitimate, mission-related employment of fair use in the field in question. And the result, when it works, and it works always to some extent, not always as well as in this case, this is an exceptionally strong document, but it works. What you end up with is a document that practitioners can use for guidance, to help them to reason through their own issues to, as I say, a robust predictive conclusion. Very important for these gatekeepers too. We've had many experiences with these codes in which professionals armed with the document have been able to go to their institutional lawyer or their publisher or their distributor and say, your rules really are silly. They don't take into account fair use. You ought to change them. That, preferably in general, but at least where my work is concerned. And they've done so successfully. Very important for gatekeepers. Pretty important, I think, to put rights holders on notice too. Pretty important to be able to say to the people who have the rights in a particular category, maybe it's Hollywood studios, which have rights to old films that documentary filmmakers sometimes want to use. Maybe it's organizations like the Artists' Rights Society and VAGA that control a lot of, or say they control, a lot of rights to the use of 20th and 21st century art. Very important to put those people on notice that the field is together on this, that the field has come to a consensus, and that individuals who exercise fair use are acting within that consensus rather than on their own. We're very proud to say that in the decade that we have been doing this work, that is, developing with communities of practice, codes of best practices, and you'll see in a moment what some of the others are, no individual or institution operating within one of those codes of best practices has ever been sued. And I'm saying that's when I make a statement like that, I have to speak with precision. And that is a precise statement. No lawsuits. Not no losses in a lawsuit. No lawsuits, period. And that's a reasonable record. Now, if and when, and I think it becomes increasingly unlikely with the passage of time, but if and when somebody should be silly enough to bring such a lawsuit, then the codes of best practices come into play in another way, and that is, for the reasons I described earlier, the interest that courts have in shared values and consensus values around fair use within practice communities. The codes, or the relevant code in any given case, would become an input into judicial decision making. The first, a decade ago, was the one that has, of course, the longest shelf life, the Code for Documentary Filmmakers. We have codes that have been developed with a variety of learned societies for scholarship in different fields. Communication studies is one, cinema studies is another. The Poetry Code is interesting because it applies both to the work of poets and to the work of people who write and teach poetry. It's been quite influential. The Association of Research Libraries Code on fair use in academic and research libraries has had a transformative effect, if I may use that term, on practice in that field, especially around issues such as course support and mass digitization, and the list goes on. That's just a small sampling of the whole. The effects, as I've said, are really quite dramatic. Documentary films have changed as a result of this development. Not only as a practical matter do documentary filmmakers find it is possible to get production insurance for the films they really want to make, a not insignificant practical matter, but they're tackling topics and using material to support their arguments that they would never have touched before. As I mentioned before, library digitization has been to a significant extent been given a big bump up by the libraries code. And all around, scholars are getting new work published, work that they might never have attempted before, or that they would never have been able to publish in that form, with those illustrations, with those quotes from poems or unpublished letters, with that illustrative material. If you go on the website of our project, which I'll give you at the end of the talk, you can see a lot of other examples there of information that we've collected about the impact, the real value to fields of this work. But now I want to talk about the code that you've got. Over the course of a year, we conducted 10 extended 3 to 4 hour discussion groups with mixed populations of visual arts professionals in 5 different cities. And when I say mixed populations, I mean that in every meeting we had different kinds of arts professionals. We had scholars, we had librarians, we had very important working artists, we had curators, and so on and so forth. And we worked with them around a set of sketch problems that we had developed in advance to highlight issues that had turned out to be particularly important in this report, to come to consensus about the question of when, in their view, in good professional practice, fair use should and shouldn't be available. And then there was a further process within CAA. CAA has a very robust committee structure, and the draft of the statement of best practices that came out of the discussion groups was worked carefully and extensively through that committee structure. And then we did at the end something we always do. Remember, we've been working now at that point with visual arts professionals for about a year, and they've been telling us what they think responsible professional application of fair use would look like. And so at the end we say, well, gosh, I wonder whether the place these professionals have come to, the consensus that has been revealed in these meetings, has anything to do with what lawyers might think about the same issue, because after all, there are legal experts on these questions. So always at that point in one of these processes, we get together a group. In this case, it was 5, very senior, very tough-minded, otherwise unaffiliated experts in the law of copyright, and ask them, does what these professionals have done here make sense? Are they coloring inside the lines? Obviously, they're looking at issues and concerns that no court case has ever addressed, and perhaps that no court case ever will address in the foreseeable future. So we can't ask our legal professionals whether the visual arts professionals' consensus is right in the sense that it says the same things courts have said. In cases where courts haven't spoken, that wouldn't make sense. We ask instead, is it reasonable? Does this look to you like a responsible, professional, centrist understanding of how fair use would apply in these situations were a controversy to emerge? And that's not a pro forma review. We go through multiple cycles with the legal professionals. We make small but meaningful changes to the document in order to accommodate their views. And then we're ready. And when we're ready, as we were last February, the document is released. And it's organized in each case around recurrent situations. And we found that there were 5 recurrent situations in which people experienced frustrations with copyright in their professional activities in the visual arts field, and wondered about the degree to which fair use might help them to reduce that level of frustration. And those were writing about art, teaching about art, making art, museum activities, and online archives, which, although it sometimes is an issue that arises in the museum context, can also arise in other freestanding ones. And so if you've got a copy of the document in front of you, you'll see that the guts of it sort of start about halfway through, are organized according to those categories. And you'll see that in the case of each category, the presentation of the information contained in the code has several parts. It has a descriptive introduction, which describes, in effect, the scope of the application of the principle. It has a statement of the principle in broad terms about the applicability of fair use, and then it includes a bulleted list of so-called limitations. And the limitations are integral with everything that has gone before. The principle represents a broad, high-level affirmation of the relevance of fair use to the range of situations that are described in the original scope note. The limitations are critical because they describe that the things that the fair use user has to do or avoid doing in order to be in the best possible position to assert fair use. Again, These are the views of the field. These are the consensus views of visual arts professionals, later vetted by legal professionals, but not emanating from them. I think that I have spoken already to the contents of this slide, except perhaps for the second bullet, just to point out that although we didn't, for obvious reasons, invite institutional rights holders who aren't themselves visual arts professionals into the small group discussion meetings, there were plenty of people in those meetings who were in fact rights holders. When a visual artist, a photographer, a painter, a sculptor, a person who works in digital media enters into one of these discussions, they do so in two capacities. They may be interested in making fair use of the previous artistic contributions of others, but they're also interested in making sure that their own stuff receives a reasonable level of protection. The same is true indeed for scholars and others who publish and therefore have copyright interests in what they publish. So these were very, very balanced groups. Again, I've described already, I think, the way, and you can again, and I'd urge you both now a little and if you're interested more later to look at the booklet and confirm this. I've talked a little bit about the way that each of the 5 sections of the code proper is organized. And I want to turn in a moment to what they say. Before I do, though, here is a slide that states 2 important qualifications about the applicability of not just the code, but the fair use principle itself to the work of visual arts professionals. Let's take the second one first. Fair use is a powerful tool. It's a right. It's a right, as I mentioned earlier, grounded in some sense, not only in copyright law, but in the First Amendment. But like other rights, it can be abandoned. It can be waived. It can be renounced. And that's what happens all the time when people sign various kinds of agreements with rights holders. Sometimes you're aware of it happening because the agreement is one that you've actually negotiated your way through, and sometimes you're unaware of it happening because the agreement is a 100 pages of fine print online, at the end of which you simply click I agree. But those are all agreements, and all of them have the potential to deprive those who enter into them of fair use rights they'd otherwise be entitled to exercise. It's true for individuals, it's true for institutions. So read the fine print, don't sign anything unless you're sure you know what it says. Encourage your institutions not to enter into ridiculously restrictive license agreements for digital materials with vendors, and so on and so forth. But remember, contract can trump fair use. That's a very important proposition. The other proposition is self-evident as well, but needs to be stated briefly, and that is the United States is not the only country in the world that has a fair use doctrine. There's a large and I think one would even say growing number of countries who have done much what we have done, sometimes in direct imitation what we have done. South Korea, Singapore, the Philippines, Israel are good examples. Australia, I think, is on their way, although there are a few bumps in the road, and they're not there yet. But it's still a relatively small number of countries. Most countries in the world don't have a fair use doctrine as such. And so when you're dealing with activities that would be governed by the laws of other countries, you can't rely on fair use. When is that? Well, broadly speaking, it's in situations where the use, whatever use you contemplate, is a use that takes place mainly outside the United States. So if you're teaching a course, if you're a visitor teaching a course at a foreign university, for example, well, then you're stuck with, in terms of choosing your slides, you're stuck with the rules of that country. Those rules may be more generous than fair use. Occasionally they are. They may be more restrictive, but they're bound to be different. Or if you're writing a book that is going to be published in a foreign language and issued primarily by a publisher outside the United States, it's probably the law of the country where that book is going to be published that matters. On the other hand, there is a common misunderstanding here that I want to take the time to correct, and that is the question of where the material you are using comes from is irrelevant to the application of fair use. If I'm publishing a book with a journal that's based in the U.S., well, if I'm publishing an article with a journal that's based in the U.S. about 20th century French painters, I don't have to be concerned about French law. U.S. law applies. U.S. law happens to be relatively more generous on these issues than French law is. Only U.S. law applies. The fact that the works that I am seeking to use as my illustrations originate elsewhere is not relevant. Okay, so let me talk about the principle that I thought might be most germane to the work you're doing, which is, of course, the first principle on analytic writing. And if you, I will leave it to you to read in detail what the, and I would encourage you to read in detail what the code has to say. Remember, there are no metrics here. There are no rules of thumb. There are no hard and fast guidelines. What we're describing here and what consumers of the code have been telling us is useful about what we're describing here is a way of thinking, a way of working through possible fair use scenarios to a robust, defensible, predictable conclusion. So there has to be a serious connection between the text or image that you're using and the analytic objective that your work is pursuing. Indeed, that connection has to be enough to be the predominant justification for the use of the work. Merely decorative or entertaining illustrative choices, if you would ever be tempted to make use of them, would not qualify. The number and kind of illustrations you employ is also something that needs to be capable of justification, explanation, and justification in terms of the purpose. So if you are using a lot of illustrations of work from a particular period of an artist's career in order to demonstrate that there were, during that period, significant shifts in some of his or her stylistic preoccupations, that may be fine, but you're responsible, just as you are in the case of the first two bullets, for being able to explain, if asked, why that is so. And if, on the other hand, you want to use images that represent the work of contemporaries of the artist, who is the major focus of your article or monograph, then you're the one who's going to be required to explain what that or what those illustrations have to do with your thesis, what common stylistic conventions or specific stylistic influences, for example, those illustrations convey. You're not asked in fair use to use the least possible material to make your point. That would be the recipe for a race to the bottom. That would be a formula for work that was compromised by design, but you are asked to be willing and able to explain and to justify the reasonable relationship between what you use and how much you use it and your analytic or discursive objective. If you're publishing in a digital format, which is of course more and more likely in years to come, then the community feels that you should be aware and sometimes especially cautious about how you reproduce born digital works, since born digital works reproduced in digital formats are obviously vulnerable in ways that works that originate in analog formats are not. That proposition, the fourth, is in a way a kind of an intensifier, if you will, or a special case pendant to the third. The groups felt very strongly that if you're going to reproduce images, and the same would be true of text, of course, in the course of an argument, you ought to do so with reasonable fidelity. You ought to choose representative images to the extent possible. And again, the burden falls on you to be able to explain why, if there is a significant deviation between the original image and the reproduction that you offer, that deviation was inevitable or may in some sense even be justified. And then attribution is important. Now the last is really interesting. You'll see it running like a bright thread, not only through all of the sections of the CAA Visual Arts Code of Best Practices, but through the more than 10 other codes of best practices that have been developed over the last decade, to which I referred earlier. What's interesting about it, of course, is that it's not part of the law. The law simply ignores the question of attribution. And by the law, I mean not only the statute, but for the most part, the decided cases as well. This is really fascinating, because when you get groups of practitioners together, it's the first thing they think about. The first thing they think about is whether or not, in an attempted exercise of fair use, the person whose work is being employed without permission is getting appropriate credit. And so it is such a common, such a uniform, such a ubiquitous preoccupation of practice communities that it doesn't make sense not to include it in their, because this is their statement of best practices. The connection to the law here is real, albeit tenuous, and that is that although law cases are generally silent about the issue of attribution as such, they do sometimes speak to the question of what they call, with frustrating imprecision, good faith. Was the act done in good faith or not? And of course, failing to attribute when it's possible to do so without tremendous effort, or when there isn't any overarching justification for not doing so, doesn't look like good faith, or could easily not look like good faith to a decision maker. All right, great stuff. If you go to the CAA website, which I will give you later, there's lots of information specifying this, giving examples, talking about ways to practice it. But you may be asking, so what? Because after all, this may be correct. This may be what the field believes about fair use and analytic writing about law, about art. This may even be what lawyers think is a reasonable statement of a reasonable and relatively granular statement about how to think through fair use issues having to do with the visual arts. But unless the gatekeepers agree, unless the publishers and the journal editors and the university lawyers are on board, who am I? A mere graduate student, or a mere junior faculty member, or even a mere relatively senior faculty member, for that matter, to insist. In other words, things have to change in the world in order for the fair use right, as documented in this very sort of middle of the road consensus way, to be really useful. So what's happening? Well, a lot is happening. And I'm happy to say that as of July 13th, the College Art Association is leading the way in this field. The College Art Association, as you know, publishes 3 major journals in the field: our Journal Art Bulletin and the CAA Reviews, which should be capitalized, and I apologize. And they have rolled out, and you can find out all about it on the CAA website, a new set of agreements with potential authors, which not only recognize but encourage authors to rely on fair use as appropriate in light of the best practices statement. This is huge. It would be huge if nothing ever happened beyond it, but more will happen, because CAA is an organization that carries enough weight in the field so that we fully expect other journals to follow suit. We believe that this shift represents a major change in the approach that over your careers, the publications in which you want to publish will take to fair use. And similarly, it's not quite as coherent, but it's noticeable. It's case by case right now, rather than at the level of institutional policy. We see other gatekeepers doing the same. There's a large handful now of important academic art book publishers who, without blowing trumpets, have in their own internal practices embraced the principle of fair use. I could name names, but perhaps it's just as well right now that I don't. I'm happy to share, and Janet is happy to share that information with anyone who's beginning to look for a publisher and wants to know who might be sympathetic to this kind of argument. I think we will see more public statements and declarations about this from academic publishers in time to come. As I've said, other journals can also be expected to follow. But, and this is a really important qualification, and I want to emphasize it, it's the third bullet here. This isn't going to happen all by itself. This is not going to happen as a result of a sort of passive set of developments. This is going to happen in part because scholars, young and old, and their institutions speak out and express their interests and their concerns and use this document as a way of doing it. There are 4 other principles. I'm not going to recite them to you at length today. Some of them may be of considerable interest. I think that the discussion of fair use in teaching, for example, is likely to be of great interest to all of you who either are already or soon will be in the classroom. And it's worth looking at and looking at carefully. And of course, museums are a big part of this picture. Museum documentation of collections online and in print has been a minefield of difficulty around fair use issues for many, many years. This document goes a long way to describing a path through that minefield, and museums are beginning to change their practices even as we speak. I think this is well worth your attention. Memory collections, as I mentioned earlier, archives are a special topic, although one of potentially great interest to some scholars. Again, there's material here on that topic. And of course, art making is a big part of what many members of the College Art Association do, so it's not neglected either. I think the statements about fair use in the document with respect to art making are pretty bold, pretty clear, and very, very, very closely in line with mainstream thinking on the question. Now, there's a lot of stuff you can find about these code or this code and its parts online. Here are two websites. The first is the website associated with this Fair Use Best Practices project of the last decade in general, and the second is the College Art Association website, and in each case there are areas devoted to fair use. You'll find lots of useful support material there, and we would be very interested in hearing from you if, when you go there, there are things you want that you don't find, because for the next year we're still in the business of improving and developing and changing and adding to these materials. And one of the things we are doing is creating an FAQ list. This I thought was going to be a sort of minor appendage to the main project, and already I think the FAQ list is twice as long as the main document. It covers a whole range of topics. Some of them may be of interest to you. No, I'll be more categorical than that. If you're interested in the subject at all, some of these frequently asked questions and answers will be of interest to you, although others may not. So I commend them to your attention. They go on and on and on, but we've tried to write them in a way that is both technically accurate and, sufficiently simple to be read by non-lawyers. They're not addressed to lawyers, in fact. So I mentioned earlier at the beginning, and I will mention again now, that Janet is in charge of this activity at CAA. She is a person to be in touch with if you want more information or there are things you would like us to add to the array of supporting materials. The one thing we can't do, of course, is give legal advice, because that's beyond our purview. But having said that, I will take a few questions.
Thank you very much for giving us this presentation. I was wondering if the committee talked about situations where the usage was free, but you're still being asked to pay for the digital file, for example, if there's any discussion about that.
The report talks about this at length, and it's no problem. And unfortunately, it's not a problem which fair use is the solvent. And it is not, because in those cases, we will assume that the entity that wants to sell you the digital file is the sole source of that material. If they're not, if you can get it or equivalent quality or less but satisfactory quality elsewhere, you're free to do so. But if somebody is in sole control of the only acceptable images of the object that you were interested in having documentation of, then they have you over a barrel. Contract wins, copyright and fair use fail. And there's no solution to that except cultural change. There's no solution to that except for more repositories. And by repositories, I mean in particular museums, because it isn't likely that source material, that the purveyors of source material closely associated, say, with artists' estates are going to change their tune anytime soon. Museums could tomorrow. And if they did, and are beginning to, and that will make a tremendous difference. Though both of the published reports speak to that, fair use unfortunately does not, except in this indirect way. Yes?
Thank you for this presentation. I wanted to ask a rights holder for permission.
Thank you. If one were to ask a rights holder for permission, and they said no, but after careful reasoning and going through, these guidelines, you deduced that the material could fall under fair use. What sort of documentation, if any, should you as a user hold on to cover yourself? Okay.
If you've got emails, hold on to the emails. If you've got just a phone call, take a note of the phone call. But Janet has something to say.
Sorry. Because quite the expert, but I will tell you, let's say they decided, just to this point, in our new law contracts, but you don't actually, we're not going to ask to see any documentation, but basically you need to articulate to yourself what your argument is about fair use, so that if you're asked, you can make your choice. But this is just a way that I think it makes sense that you just have to be able to say why they're using it.
If you're trying in particular to document the fact that you asked permission to return, which can be a very good thing for fair use. Suppose somebody would say to you, for instance, I will never license that image for any scholarly use. Or suppose someone were to say, I know who you are and what you're about, and I won't license that image for your scholarly use. Both of those are really, really good answers from a fair use standpoint, because both of them suggest that it is the rights holder who is renouncing whatever they may have, rather than the scholar who is invading that market. So that's how it's gold. If you have even a flat no without explanation, it's better than nothing. So keep what you have. Keep the email. Keep your contemporaneous note of the phone call. Keep the exchange of letters. If anybody ever these days actually would exchange of letters. And that goes in the same file that Janet has described as being the one in which you might jot something down about what you're doing this.
If the rationale of fair use isn't evident from the work itself, why should supplementary subsequent testimony have any force?
Because the standard is the purpose of the user, and the user is the person who has the most information about why they did what they're doing.
Yes, but it's not going to be convincing unless it's actually...
Legally it is. Courts, look, courts do this all the time. They try to figure out what people are thinking, or were thinking, by listening to what they say later. They have, relatively good bullshit detectors. So a plausible after-the-fact statement about why you did what you did when you did it can be very persuasive. Now, you don't have to speak up. You can, if you choose, say nothing. But in that case, I would say, you diminish your own chances of success. And in a sense, maybe you mess things up for everybody else a little bit too.
From the artist end to the art scholar reviewer end,
Yes.
is like an artist in their studio can make anything, but is the problem at the point of exhibition or just at the point of reproduction? And then both. Okay. And then can the reviewer scholar inadvertently either get the artist in trouble or in trouble themselves, or who's the one making, at the point where you may be the first person publishing this work in a review, are you the person making the fair use argument, or does it then fall back to the artist?
Your fair use argument is easy. I mean, your fair use argument is trivially easy as long as you're writing a serious discourse or comment about the work. And you are potentially exposing the artist as well, of course. And presumably, therefore, you should have some understanding of that with the artist. Yeah, I wouldn't think it was ethically responsible. It's not addressed anywhere in this code, but I would not myself think that it would be ethically responsible to put someone in harm's way through one's own publication without at least giving them notice of the fact that you're doing so. Others may differ. It's not in the code, but it's an interesting question. Please.
Can you just speak briefly about what it means for an image to be in the public domain and how that relates to the concept of fair use?
But it won't be all that helpful. It means that one of several things may have happened in the history of that image which have deprived it of copyright protection. And the classic example, even though we haven't seen very many instances of it in recent time, is when something has simply aged out of the copyright system. So, you know, by the time you get to 19th century material, you can be pretty sure that it's just too old. Published material after the early 1920s, before the early 1920s, is in the public domain. Unpublished material is less clear. But that's one way. And then the other way is if there's been some, well, it could have been a mishap, I suppose, or it could have been an intentional act along the way. So it used to be, and I want to stress, used to be, it hasn't been the case for 25 years, but it used to be that in the United States, in order to keep your copyright, you had to renew it after 28 years. Well, some people didn't renew their copyrights, and so there are a certain number of works that entered into the public domain 28 years after their first publication. And you can, by doing library and archival research and consulting the records of the Copyright Office, you can usually figure out if something falls into that category. And then there are things that get sort of ejected into the public domain more brutally through some kind of mistake that someone made. It used to be, for example, that when you published something in the United States, you had to use a copyright notice, that little C in a circle with a name and a date after it. And if you didn't, you'd lose your rights. That hasn't been true since in the mid-'80s, but it was formerly true. And so some things entered the public domain willy-nilly at a point at which either a first or a ninth edition was issued without a copyright notice. And then finally, and perhaps significantly, there's a kind of new generation of things in the public domain which are there because people have actually chosen to put them there. So a CC0 license, for example, would be a good example of something that's in the public domain. It's not in the public domain for any of the reasons I've stated, but because somebody who has the rights has said, I hereby renounce those rights publicly and permanently. That's another possibility. So the difficulty from the working scholar's standpoint is that it's often very, very hard to tell without doing an extremely deep dive whether or not a particular work is or isn't in the public domain if we're talking about 20th century material. And sometimes you can spend weeks and months and still not come up with an answer. And sometimes you can't even figure out for sure where to start, because you may not even know who the copyright owner was. Those are so-called orphan works. So those are situations in which, even though there's some possibility that the work might have public domain status, it's very useful to have fair use as the other string to your bow. Janet. Well, we could. That's another kind of layer or kind or class of layer of rights. Fortunately, we have case law that states that documentary reproduction of two-dimensional images are not copyrighted, are in the public domain, because they're not sufficiently original to be protected. So that's another very good example. It doesn't necessarily apply to documentation of three-dimensional images, however. Good example. Thank you, Janet. A few more. Yeah?
But photographs, documentary photographs, and three-dimensional sculpture, even if they are copyrighted, are still valuable for fair use.
All subject,
right? Not,
but perhaps not in the public domain.
Right. So it's still just a matter there of appropriate captioning of the photographer. That would be the key.
Appropriate captioning, I would say, more than captioning, I would say framing. I would say framing, captioning, in the integration into the argument,
right,
and all of the other points documents that were featured in that list of that bulleted list of limitations. Yeah, absolutely. Please.
Thanks. Can you explain how fair use applies to unpublished materials consulted in an archive? And specifically, I've been a little bit confused by archives that say that you can use material for like your own personal use, but not publishing, and it's kind of implied.
Well, how do they say that? Do they say it? Is it like on a notice board, or do you sign something?
Probably when you sign something.
You sign something, you start with what you sign. That's the start.
So does this mean like if you wanted to quote from a unpublished correspondence, like even if there isn't a reproduction involved, is this outside of, like you don't have fair use to use that material?
Well, no, I'm not sure I understand the example. So I go to the archive and there is an unpublished one.
Yeah, let's say an exhibition archive and there's correspondence between a curator and an artist.
I agree that I won't use that material except I won't publish it. Okay? And then I find the same thing someplace else. I find it outside the archive. Is that?
It's unlikely. I think if I'm researching in an archive, I see a letter that I think is interesting for my research, but the archive has specified that the use is only for personal or study use, even though I'm a scholar coming to the archive.
You start with what you sign. Mm-hmm. Well, then, if you should discover that that material is actually no longer available only in the archive, if you have it from another source, you may be able to ignore the agreement. But if you are using the material pursuant to the agreement, the contract trumps the default settings of copyright law. And that's why I say really have to be careful about what you sign.
Yeah. Well, often you're not given much of an option. The archive is not accessible.
That's not always true. Mm-hmm.
Yeah.
One of the things that's tremendously interesting, and I know this not only from talking to scholars, but also from talking, we work with a lot of archivists as well, is that there is a surprising amount of room for negotiation in those agreements. It's not always taken as you see it. So if there is something in that agreement that is going to frustrate you from completing your project, you ought to stop then and see if you can work through that to a modification of the agreement rather than accepting it as the only possibility. It may not work, but I know in cases in which it has.
Is it legally possible if you have signed an agreement and later wish to publish something, like to contact the archive and to say this is, my dissertation chapter, it's going to include this quote, and, would you consider, releasing the...
Could you go back to that?
Yeah, would they be allowed to rescind their...
In that case, they have a witness.
Yeah.
So I would say if you can get the arrangement right the first time, you're in better shape. But unfortunately, again, fair use is a powerful tool. But if somebody else is the only source of material that you think you need, then they're in a position to dictate terms. Mm-hmm. Ultimately, once you have a nice robust negotiation. Are we doing our time? We're there? Thank you all so much for coming. This was great fun. Read, think, enjoy, and be back in touch if there's anything we can do to help.